Thank you so very much. Yes, as a woman, let's take it from that point. What will be your preliminary comment? I've had some women advocates in the, women advocacy groups reach out to me and say right after the press conference that, oh, gee, is that what she's going through? And why is her husband not being allowed in to give her support? What's crime if that is allowed? All of that.
Thank you, Samson, and good morning to my fellow panelists. Yes, of course, I'm concerned, not just as a woman, but as a Ghanaian citizen, because these are constitutional issues that affect all of us. I would have wished that she had respected the constitutional procedures or the procedures that emanate from Article 146 that have been put together, and respected the fact that these proceedings are supposed to be held in camera. And so I don't really understand, although I hear her reasons, and if they are true, of course, we will all be concerned about them, but we are only hearing from her side at the moment. And it's the whole point not to put these issues in front of these eminent people who, when you look at the panel, there are some very eminent people there, people who understand presenting your case, looking at the facts, looking at the issues, and then making decisions based on what is presented before them. So would it not have been better for her to, as someone who is a Chief Justice of this nation, to respect the Constitution and actually wait and let the hearing go through and then talk to us if she felt the need to talk to us? I mean, you said we'll examine it in detail, but my initial reaction is no, I don't think she should have gone to that extent.
Let's start right with you, Vicky. So you are saying that she failed to respect Article 146, Clause 8, which says that all proceedings in respect of the impeachment or removal of a justice of the High Court or a justice of the Superior Court or the Regional Tribunal, NCC, EC, all of those places, the process must be in camera. Have you not heard the lawyers who speak for her, including Dana Sunabadapa, Frank Davis, all of them saying that her human rights ought to trump this particular provision, secrecy provision? What do you say?
Something, look, no one is bigger than the Constitution, okay? We are all subjected to it, from the president all the way down to you and I. And it doesn't mean that it's perfect, but we cannot chop and change it as we wish or when we don't like something. This is not the first time Article 146 has been invoked. Okay, we've seen it being used against Charlotte Osei, Loretta Lamptey, and some Superior Court justices. So we are aware of how it works. I'm not saying the process is perfect, but this is what we have at the moment until we change it. Okay, and it is the first time it's used against the CJ to this extent. I mean, we have the Bright Akwete petition under President Kufuor, but it didn't, because of the legality of it, because the legality was questioned by Ajay, it did not proceed because the Supreme Court agreed with Mr. Ajay that it was illegal. So this is the first time we've gotten this far with a Chief Justice. And as I said, for me, all these matters will come before the committee and they will give due consideration and make a decision accordingly.
She's not getting justice before the committee. That's all she's saying. She says every step of the way, every rule that she knows in justice delivery is being broken in this committee. You say she should submit herself to it and then in the end complain?
Something, we've never had Article 146 hearings done publicly. So why now? Look, Daniel Ofori, for example, if I just go through some of the specifics of what she has been saying. Under Ghanaian law, there are decided cases that Daniel Ofori as a party to the action is not obliged to testify, is he? I mean, there are lawyers in this room. He's not obliged to testify. And as far as I know, and I'm happy to be corrected if I'm wrong, no one else has been allowed to bring their spouse into these hearings. If that is not the case, then let me know. But as far as I know, so far, with the Article 146 hearings that we've had, spouses have not been allowed in.
Okay, so just hold on. Because I want us to use this platform to fact check a few things. And if you are not tuning in, tune in, because I don't want you to miss today. She just said there are lawyers on this table. She wants to confirm from any of you whether the law you have studied is as certain as some say. Is a party in a case under obligation to testify? Yes, Ediji.
So, Senior, once again.
Very quick, let's not, she's the one speaking now.
In the recent election petition, President John Dramani Mahama and Nana Addo Dankwa Akufo-Addo, the Electoral Commission, the Supreme Court settled the matter when there was an application to compel Madam Jane Mensah to testify. The court said a party is not bound to testify. So that matter had been judicially settled.
In fact,
without
so hold on. Herself said that has Jane not got a human right not to testify? She herself in that ruling.
Okay, you're not a lawyer. I was asking.
But she said we all listen, we all watch it.
Hold on.
We need lawyers.
In Ray Asalbuchi, the Supreme Court again settled the matter that a party is not bound to testify.
Okay.
Anybody, you can call the person.
Thank you. She's the one still speaking. Yes, Hassan.
As far as I'm concerned, I think
here's a question. Here's a question.
I want to answer the same question.
Is a party in a matter under obligation to testify in the matter?
A party,
yes or no?
No, you have to put this in context. Because this is
yes,
Article 146.
Or say no, then you answer.
No, because we are dealing with Article 146. And Article 146(7) provides that the committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. So, really and strictly speaking, this is not a court litigation. This is a committee of inquiry, because the law says that shall inquire.
Wait.
It says shall inquire. So you are a committee set up to look at
Hassan,
facts.
Your answer
and
was
then advice.
Your answer was no. A party is not under obligation.
It depends, yes.
It's not under obligation, but you are making an exception, right?
In a litigation, in a court litigation, obviously a party is not obligated.
Thank you. Hold on. But you say the general rule is that okay, that's the general rule. But in this case,
but in this case, the party is not obligated.
Thank you. Okay. So let's go to Vicky back. All right, let's hear you continue with your submission.
Yes, so I agree with what all the lawyers have said clearly, because that was my assertion that Daniel Ofori is not obliged to testify. The decided cases have been mentioned. The recent one on the election petition, Nyami versus Ansai, and then Ria Salipote, etc. So for me, that is now decided. That's decided law as far as I'm concerned.
The question that springs from that, and I'd like my viewers to come along with me, let's learn. Sometimes it's important. You just can't, do anything around that. Is the litigation kind of cases and precedents you are using to support what she claims the commission is doing, the committee is doing, is it the same as an inquiry?
Well, the law is the law, Samson. We cannot operate, the law in silos. That is what the law is. And in a commission of inquiry, I think there's also a decide. The same Ajay Chum before Justice Akufo said that they are allowed to make their own rules, right? It's an ad hoc, and they are allowed to make their own rules. I don't think that we can operate in a vacuum. With this Article 146. So I'm using these examples to buttress the fact that, Daniel Ofori, just as Jane Mensah was not obliged to testify, he is also not obliged to testify before the committee. His petition, I believe, is before the committee, right? And also, what our understanding is that the Chief Justice got details of it from the President when she requested for it. So she also knows what it says. In fact, it's all over the news now, what all these petitions contain. So that is my that is my starting point in all of this. I mean, the threats that she's talking to are obviously very serious.
Right. Vicky, hold on briefly for me, and forgive me, but I'd like us to do it this way a bit. Tied to this matter of the excusing the petitioners from getting into the box and she also cross-examining them rather than they calling witnesses and not showing face. Tied to that is what she speaks about as the conduct of the proceedings in a typical adversarial litigation manner, contrary to procedures of a committee or commission of inquiry. I read her. It is important to state that even though there is no constitutional instrument passed to regulate the proceedings of an Article 146 committee, we have on the statute books of Ghana a constitutional instrument regulating the work of all commissions or committees of inquiry. This is the Commission of Inquiry Practice and Procedure Rules 2010, CI 65. And in Article 1467, if a committee is set up for the removal of a chief justice, the committee is supposed to inquire into the petition, the answer and the prima facie case. In spite of this, on the 15th of May, the committee indicated that it will conduct the hearing not as an inquiry, as directed by Article 1467, but as a regular litigation. The committee rejected the use of CI 65, which is created for the conduct of an inquiry, and stated that they will rather use the High Court Civil Procedure Rules 2004 CI 47. What do you say? She says this is wrong. They are supposed to use the commission or committee of inquiry, rules rather than CI 47.
The difficulty she has is that we have to work with what Article 146 says, and the interpretations that have been given by the Supreme Court of Article 146 and the committees emanating from Article 146 when prima facie cases are established, okay? And as I was saying earlier, in the same Ajitrum case that we've been talking about, Justice Sophia Akufo at the time held that the committee formed under Article 146 is an ad hoc committee and is free to determine its own rules. So if it is deciding that it wants to go in a certain direction, then, then they are allowed to do so. Now, it doesn't mean that we are happy about what they decide or what they don't decide. And I started off my submission by saying that we may not be happy with every article under the Constitution. We all know it's a living document, right? And laws in it. And this is why, from time to time, various presidents set up committees of inquiry to look into
the question that comes up. The question that comes up, Vicky, is that you are referring to a Ajitrum, where the Supreme Court said the committee can make its own rules. That was in 2005, 2006. But the rules that she's referring to, CI 65, was made in 2010. Shouldn't the rules specifically made override the court's decision?
Something. The law, we have various types of laws, right? And they all are supposed to work in tandem with each other, unless they are specifically repealed. So unless something is specifically repealed, or in a case of a decision by the court, unless it's reversed, in this case by the Supreme Court, since they are the sole interpreter of what these constitutional provisions mean, we have to go with it. Mm-hmm. Of course, I respect the fact that we all have human rights and these human rights should be respected. if I'm sure that if you speak to Charlotte Osei and Loretta Lamte and all those Superior Court judges who were removed, they would have the same sentiments that they felt that their human rights were not respected. So the point I'm making is that we should stick to what Article 146 says. We need to stick with that. And if we are not happy with the way it operates, and we all have seen the flaws in the operation of this particular article, then we need to put it before. Luckily, we have a Constitution Review Committee going on now. We need to place it before the committee so that they'll look into it in more detail and fix the gaps in its operation.
All right.
But what you cannot is chop and change things to suit your situation. And also this interpretation. I mean, has this whole thing not been put in the bosom of the President of the Republic acting in conjunction with the Council of States? I mean, why is one person, I know she's the Chief Justice, she's the Justice of the Supreme Court, but while it's not subject to one person's interpretation, we have to respect that this is not, this has been put into the bosom of someone else, not her. So you can't come and make your own rules just because what is there does not suit you.
Okay, I think I will have you also comment on this part. Then I come to Hassan Tampoli, who has a divergent view to these circumstances. She says her lawyer, and this is not the first time, she's just repeating it to us, that the very first time the committee sat, her lawyer appeared and her lawyer was not recognized in her absence. She says this breaks every rule she knows. What do you say?
Well, I believe her lawyer should have been recognized. I mean, I think that if someone has representation and that representation has been made known to the committee of inquiry, the court, whatever it is, the person's lawyer should be recognized. There are situations where this is difficult. I mean, we have this kind of Koreata thing going on, for example, but I think that if someone has legal representation, it's important that the legal representation, the legal representative of the person is recognized. And if the person's presence is required by the committee, then they should make that clear that, we need your client in next time.
The committee will definitely not speak because of the injunction in Article 146, Clause 8. But I'm beginning to read into their minds. Do you think that the reason on that day they refused to recognize the lawyer was like a typical inquisition? If an accused person was brought before a court, there were charges brought before a court that the accused person does not appear, and a lawyer showed up to tell the court that I represent the accused person. Do you think the judges are entitled to ask a question? Do you really have the capacity to represent the accused person?
Well, you don't in a court situation because, of course, the accused person must present themselves for the trial. This is a commission of inquiry, and so they can decide how they want this to be conducted. But it's also not realistic to expect that a whole inquiry can be made on your behalf without you being present. I mean, you have to be there. So that the legitimate questions that the committee has can actually be put before you. If the lawyer is not privy to every single aspect of some of these things. So there may be certain types of information which are solely in your knowledge.
Okay, thank you. Let me come to Hassan now. So Hassan,